preliminaries. Good morning, good afternoon, good evening, whatever time it is, wherever you're joining us from, and welcome to this International Insolvency Institute Special Members Meeting and webinar on COVID-19 legal and practice responses globally. We're going to be missing the opportunity to meet and share experiences in Hong Kong and New York this year. And this special meeting, which was organized by Dr. Janis Sarra with assistance from Sherry Becker and Annika Wolf, will allow us the benefit of timely and thoughtful comment from 7 of our members, reporting on the measures that are being taken globally in response to the challenges to liquidity and solvency caused by the pandemic. Can everyone hear me? I'm seeing some, okay, good. Each speaker will speak for 5 to 10 minutes. After that, we're going to open the meeting up first for written questions that we encourage you to send in during the presentations using the chat function on your computer or iPad. Then we'll open the meeting for those of you who may wish to make additional comments using the raise hand function on Zoom. Sherry's going to unmute you when I recognize you for your question or comment in the order that we receive the questions by the raised hands function. Finally, we'll hear from our president, Deborah Grassgreen. Please note that the meeting will be recorded and will be available on the III website for our members who are unable to attend the live session. Our first speaker is Dr. Janis Sarra, who's currently Professor of Law at the Peter Allard School of Law at the University of British Columbia, and recently a Presidential Distinguished Professor. Janis is, of course, a prolific author, a sought-after speaker, and an innovative educator, whose current interests include the cross-border resolution of financial institution insolvency, climate-related financial risk, and fairness in financial markets. So Janis, over to you.
Thank you, Barb, and good morning, afternoon, and evening, everyone. It's great to see so many faces among our membership. I'm going to be very brief, just by way of introductory comments. The first is that we appreciate, all of us who are speaking today, that this is just a snapshot of what's going on around the globe. But the advantage is, of course, you're having a snapshot from some of the most distinguished speakers there are among our membership. And so the information is accurate and finely tuned, but they've all expressed a willingness to provide more information if needed. The second is just to point that there have been a large variety of strategies that are being used to address the COVID-19 pandemic. There are legislation-based strategies, practice-based strategies, and of course, court-based strategies. And although they differ, you will see some similarities, some resonance about how we are trying to maintain the fairness and efficiency of the system. And then I think the third thing I just want to note is that an important challenge for all of us going forward, as well as governments and capital markets, will be to ensure that companies that have viable business models can access capital and make the types of investments that they need to adapt to a very changing, rapidly changing structure of the economy. And this, I think you may have heard the buzzword backstop, not bailout. And I think it will be very interesting to hear from our speakers about measures now, measures as we exit the pandemic, and speculating, all of us, I hope, on what lies ahead. So with that, I'm looking forward to hearing our speakers, and I'm turning it back over to you, Barbara. Thank you.
Thanks, Janis. Our next speaker is Patrick Ang. Patrick is managing partner of Rajah and Tann in Singapore and vice chair of Rajah and Tann Asia. He's had almost 3 decades of experience in national and international restructuring and insolvency matters. And he was on the Singapore government committee that produced the COVID-19 temporary relief legislation. No one is better to advise us on developments in Asia. Patrick, over to you.
Thank you, Barbara. Hi, good evening from Singapore. The Golden Gate Bridge behind me is not real. I just want to spend a few minutes to introduce to you that, like many countries around the world, Singapore had their own version of lockdown, but the government decided to call them circuit-breaking measures. All right, and the circuit-breaking measures are in place for the months of April and May, where basically the concept is everyone is to stay at home, except for very essential businesses. Government just announced today that 1/3 of non-essential businesses will restart from 1st of June. Exactly who will be in that 1/3 is still not clear, but it will be made known in the next week or two. Barbara mentioned the COVID-19 legislation that I was a part of. This is a record in our government's history. We drafted the legislation and got it through to Parliament from day one to the finish line in 9 days. We consulted enough people, we felt, to make this work. And the legislation basically was to provide relief for certain sectors, which I will brief you on very shortly, where we believe there was a critical need to help companies who are unable to perform contracts because of legislation or because of regulations arising from COVID-19, or simply because of the effects of COVID-19. Now, at the same time, we added legislation that allowed meetings and court hearings to be conducted by video conference. So for the months of April and May, I just did a hearing last week where we had 55 law firms with about 200 lawyers attending a restructuring of a company's scheme being heard completely by video. Now, in addition to that, I'll also brief you that the government has come up in Singapore with a lot of financial aid, which is quite unprecedented. To give you a quick idea or scale in relative terms, when the government looked at the global financial crisis in 2008, they came up with a package of measures in 2009 amounting to about $4 billion, all right, in addition to the usual budget. But this time round, the increase in budget, even if you factored in inflation, the increase in the budget purely for COVID-19 was close to $50 billion, almost 11 times the size of the previous assistance. I'll now quickly bring you through the relief that we figured was necessary as what we call phase one. There is a phase two, which I am unfortunately unable to speak about, but as we speak, we are in the midst of planning phase two. So what I'm going to brief you is simply phase one. Phase one included the increase of debt thresholds and periods that a person can be made a bankrupt or wound up. I won't go into details, but in short, we are not seeing any bankruptcies or winding ups in the months of April, May, and unlikely to see any for the month of June as well. Next slide. Now, when I mentioned the areas in which we were looking to provide relief, you will find that we categorize them into 5. First are leases for non-residential, meaning commercial property, commercial industrial. 2, construction and supply contracts. 3, tourism, which includes aviation, travel, and events related contracts. As you know, Singapore is a huge air hub, not just for Asia, but actually beyond Asia. We are also we have quite a big business catering to conventions and related events and exhibitions, which has come to a halt. Hire purchase for machine and equipment, particularly, and vehicles. And finally, relief for those companies who are small, medium enterprises who have secured facilities. Now, the effect, just to make it very simple for this presentation, is simply that if you fall under these scheduled contract sectors, you will be allowed to send a notice to your counterpart on any particular contract related to these areas, alleging that you are unable to perform the contract, and for a period of up to 6 months, you are allowed to you're excused from performing your contractual obligations, right, without any penalty. We also added a system whereby we got together close to about 750 professionals on a low bono as opposed to pro bono basis under Ministry of Law to assess disputes arising from these notices being issued where people allege that they are unable to perform when they should. And that drew inspiration from the cases of Adidas and H&M in Europe who alleged that they could not pay rent. Right? So to avoid those situations, we provided an assessor system. So that's in short the relief that we provided. And I'll quickly go through now some of the government schemes that we can talk about quite openly. First is a job support scheme. For the months when circuit breaker or lockdown was in place, the government paid for 75% of up to 4,600 Sing dollars of employee salaries, which is quite a huge bonus to many companies because wages is usually the largest cost of any company. Property tax rebates were granted 100%, and it roughly translates down from the landlord to the tenant to about 1 month's rent. SME loans of up to 10 million Sing dollars was guaranteed by the government if they were approved by the government of up to 90%, which basically allowed the banks to be more willing to provide loans to SMEs. And basically there were measures by MAS, which is the central bank in Singapore, to provide for lower interest rates for loans during this period. And I come now to my next slide.
Okay.
This is my last slide.
Patrick, I just have to interrupt to remind you, you have about 2 minutes left.
Okay, great. I'm on time. Yeah, I just want to quickly talk about Malaysia and China, where you basically see a slightly different approach in Malaysia, where they did very little on the legislative front, but they did targeted help, but very narrow targeted help compared to Singapore's wider targets. But they use a lot of pressure through central bank. So that's in short, Malaysia. For China, the approach in terms of this sector focused very much on employment policies, central bank policies, as well as tax and social insurance. So that's in short, some of the approaches in Malaysia and China. And finally, my last minute, I just wanted to comment that there is a phase 2, which the Singapore government is looking at very carefully, because we believe many businesses will not return to normal, even if we got out of lockdown in the next 2 or 3 months. And that the estimates from what I know from discussion in many various industry sectors is that any business, even if they're doing well previously, would see at least a 40% drop in business, even post-COVID, if lockdown was lifted completely. Right? So on that basis, I think there is a lot of room to discuss what we need to do to help companies who are viable but will have a debt overhang moving forward. I'm happy to hear other speakers' views on this. Thank you very much, everyone.
Thank you, Patrick. Our next speaker is Dr. Ignacio Tirado, who is the Secretary General of the International Institute for Unification of Private Law. Prior to his appointment to UNIDROIT in 2018, Ignacio taught at the Universidad Autónoma in Madrid, and he has held senior positions at the World Bank, where he worked extensively on assessment and legal reform in a number of countries globally. He's worked as a consultant with the International Monetary Fund. He's a founding member of the European Banking Institute, a former director of the III, and a fantastic cook. So Ignacio, would you speak to us about Europe?
Certainly. Thank you, Barb. Can I move on to the next? Thanks. Right, so it's great to see all of you. My task is very difficult because I'm supposed to summarize what's going on in a regional organization covering 27 states, as well as to provide some of the main measures in 3 out of the 4 largest jurisdictions in Europe, as well as I thought the Netherlands. My idea was to present a comparison between Germany, Italy, and Spain, and also incorporate the Netherlands because it is trying to become the substitute for the UK. and is therefore betting strong on the insol market. But I have realized, interestingly, that the Netherlands has been very consistent in its policy towards this pandemic. Is one of the countries that had adopted the most lenient measures in terms of social distancing, etc. And they have done exactly the same in terms of insolvency. Can I ask you, Shari, to move on to the next slide for a second? In the official report that they furnished the European Commission with, they say we don't suspend the duty to file as this risks to keep unviable enterprises alive. We are very much pro-creditors, and we just focus on facilitating speedy restructuring. Therefore, there are no measures in the Netherlands that I am aware of. So the Netherlands has nothing to report, so I'll just concentrate on the other three countries. Can we move back to the first slide? So as to the European Union as a whole, there is no unified action in terms of legal reform. Each country is doing its own temporary legal reform. This is only consistent with the fact that there is no unified or harmonized substantive insolvency law within the European Union. The Director Generals of Justice, DG Justice of the European Commission, however, has been very active in gathering information and sharing the information with everyone. Is acting as a focal point, and is also helping mediate and negotiate some of the measures at the governmental level. This is very important, especially because it becomes a true nightmare to know which measures apply and which laws are applicable in the different European countries nowadays. And I just included in the slide the case of, for example, temporary measures concerning cross-border judicial action. Therefore, the inability to enforce decisions cross borders within the EU is, if you want to know if you can do that these days, you need to go to the European Commission website where they share that information. Otherwise, it's very difficult to know. A very important element also is not yet translated into a fully fledged policy action, but it is pretty clear that the European Commission is going to allow some forbearance concerning state aid restrictions during the crisis and in the months to follow. This is very important because, of course, it explains, this relaxation of the competition rules within the EU will allow states to provide us financial assistance to distressed companies, to provide liquidity, and also to guide the behavior of public creditors in the restructuring of entities. So this is very important. This flexibility is going to be very much necessary, and it's going to happen, hopefully, I think. But so it seems. As to the economic measures, things are still undefined. We know that the European Investment Bank is going to be financing some good money coming to the markets for SME financing across Europe. And then whether those countries most affected by the crisis are assisted by means of the official financial assistance of the European Stability Mechanism, or a purposely set up fund as it seems now, we don't know yet. So we are still waiting for the final measures. But they should be out very soon. We just don't know how it's going to look. It seems pretty clear, though, that most countries receiving aid will at least not be subject at the beginning to strict conditionality. So all the trouble that we lived through with the Greek and crisis and the crisis of the some Southern European countries is not going to be tackled the same way. At the state level, interestingly enough, Italy has decided to postpone the entry into force of its major insolvency reform, which was planned to come into force this summer. And they've done that forced by the situation, because it was a legislation for out-of-court restructuring, pretty much based on early action measures. And by definition these days, every single, if not every single, the vast majority of Italian enterprises would be in a situation of early action triggers. So it's good that they postpone this reform on to next year. Spain, however, has decided to accelerate measures, the legislative measures, and we will be implementing, hopefully soon, a transposition of the restructuring directive soon. As to the ad hoc specific rules to tackle the crisis, crisis for enterprises that has been created by this absolute paralyzation of activity across Europe, I have clustered them into different types instead of describing each country quickly. First of all, the most common and evident of the measures has been to suspend the duty to file that countries such as Spain or Germany had in their legislation. The Germans have suspended the duty to file in case of insolvency of the debtor until the 30th of September, although this might be also extended up to March of 2021, merely by a decree of the Ministry of Justice. I should say, though, that this duty to file is not for this suspension of the duty to file, this waiver of the duty to file in Germany doesn't happen for every case. It will not be suspended, the duty will not be suspended in case the company was already cash flow insolvent, according to the accounts, the financial accounts of 2019. And then there is the presumption that the insolvency of the cash flow insolvency was caused by the pandemic. But if it was not, then the suspension doesn't apply. And it's also necessary, and this is very reasonable, that the entrepreneur or the company that decides not to file for insolvency can actually objectively be in a position to overcome difficulties in the future. Spain has been less nuanced in its action. It just says no duty to file whatsoever during the rest of the year. So there's no duty to file until the 31st of December of this year. And the difference with Germany is we don't think we have the time or the possibility or the means to analyze case by case. So we just full stop remove the duty to file for these months.
Nacho, I'm sorry I have to interrupt you. Can you wind up in a minute?
Yes. Okay. So another measures are creditors in Spain cannot file for insolvency. Something similar happens in Italy, and this is going to be the case in Spain until the end of the year. Italy until the 30th of June. Can you just move quickly to the next slide, please, Shari? Some measures have been adopted to foster credit and protect credit. The main problem is liquidity, obviously. So measures have been adopted to ensure that credit flows to the companies during this crisis and in the months thereafter, at least to some extent. They've done that both, all three countries, Germany, Spain, and Italy, by removing the subordination of loans from shareholders and group companies, which was in place. Which is evident if a bank is not going to lend you, only your shareholder will, if at all, if the company is viable. So that has been removed. It's a very important step. And there have been also other measures such as the reduction of the possibility of liability of directors under in certain actions that can, and payments and that can be conducted during this crisis in Germany and in Italy. I think I should finish here. Just a final word to say that basically for each of the countries, there has been, at least for Italy and Spain, measures have been implemented to postpone payments for tax duties and also social security in the case of Italy and Spain. And I think I'll just leave it here.
Thank you, Nacho. We asked you to cover quite a bit. Okay, we're going to move to Hélène Bourbouloux, who is the managing partner and a founder of FHB, Administrateur Judiciaire in France. Ms. Bourbouloux has had over 20 years of exposure in restructuring matters, particularly in the field of European insolvency proceedings, with involvement in a number of high-profile matters. Recently, she was quoted in the Global Restructuring Review, commenting that the pandemic could lead to the modernization of France's insolvency regime. She's a director of the III and will speak about developments in France. So, Hélène?
Thank you. Thank you to you, Barb, and good morning, evening, afternoon to everybody. I'm very proud to discuss with you this afternoon. I tried to make it short in 5 minutes, and I try not to repeat what has been said before by Ignacio, and very well. So we have the similar measures that has been taken in France. First of all, I would develop 4 points. First one is the French state support measures. Like in other countries, the French government took immediately, the day after the lockdown, a lot of measures that has been seen like very efficient in the first stage. And the main of them, both of them, were the short-time work scheme paid by the state, meaning that the company had the possibility to let people at home working when possible, and when not possible, paid by the state and not by the company. So it's something that has a huge success, and a lot of companies used this short-time work scheme. Second one, very important, was the postponement of social and security tax debts that has been postponed immediately for March and April, and that has been extended after in the second stage for companies and small stores who were closed by administrative measures like restaurants and coffee shop, etc. So for those businesses, social taxes has been definitely cancelled, but it has been announced in a second time, not immediately. The third very important measure, among a lot of them, is a loan that has been created by the government in cooperation with French banks, that is called PGE, Prêt Garanti par l'État for French speaker, meaning a loan that is guaranteed by the states up to 90% of the face value of bank loans, capped, and the amount that is possible for this loan is 25% of the annual revenue, or in some cases twice annual payroll. Banks are the final decision makers, meaning that the banks have the obligation to appreciate the reality of the risk, and if they consider that the company is in situation to repaid and pay back one day the loan that has been granted, they are authorized to grant the loan, and they are benefiting of the guarantee of the state up to 90%. For biggest companies, the guarantee could be only 50%, but security can be granted. This PGE is something very. Finally, I'm a bit criticized about the system, because it's something in the middle. It's not equity or subvention, because it's a loan, but in the same time, it's not super senior or rescue money, because it's a very low price. The banks are not authorized to take any margin. It's not based on assets. It's only guaranteed by the states. The whole amount of this loan is evaluated by the states at 300 billion of euros. And as of today, 60 billion have been deployed by the banks. So it's something we are not sure that it will be workable in the time, because probably that part of those loans can't be repaid by the company. It would be probably preferable to take something like Germany did with direct help in financing of the company, not through loans. So the main difficulties with the governmental measures is probably that it's constituting a debt creation, and we can wonder what solvency capacity can be expected. Second point I wanted to raise is the legal tools for dealing with difficulties. As of today, no new proceedings have been created. We consider that the French system is very complete, probably very complex, but also very complete, and that it can be it can be the right one to help companies because we have a lot of proceedings like reorganization, safeguard, but also pre-insolvency proceeding that are very useful for the company today. But we probably, we obtain the strongest adjustments of this French law. And as it has been explained by Ignacio, we have the duty to file has been postponed till 2 months after the end of emergency sanitary period, meaning that it's now in September. We are considering the state of the suspension of payment is assessed based on the situation on 12th of March. So there is a lot of adjustment with the goal of freezing the situation. Contractual and procedural extensions of time limits also has been decided not to penalize the litigants and extend the time taken to act in conciliation or collective proceedings up to 6.5 months. Next slide, please. If we focus on judicial activity in France during lockdown, we can say first of all that like in other countries, commercial courts continue to function, but with some main adjustments. Online registry, electronic hearings with widespread use of video conferencing. It's something very new for French courts. I think that 1 month before, nobody could probably have imagined that it would be possible. And we can notice that in France, a lot of commercial courts have been very flexible compared with the drastic closure of civil courts. So there is a big difference between the flexibility in the commercial courts, having decided to organize the hearing by video, by conference, phone call, compared with civil courts, who mainly have decided to postpone all pending cases except very, very urgent matters.
Hélène, I'm sorry, we've asked you to say quite a lot in a short period of time. Can you wrap up?
Okay.
Your time is over.
Okay, so the biggest wave is expected this summer and more probably from September. And we suggest that it's necessary to promote financing granted to buyers and to create new money privilege in order to finance continuity plans. And for the rest, I suggest you can read it in the PowerPoint presentation. And thank you for your attention.
Okay. Thank you, Hélène. Our next speaker is Chief Justice Geoffrey Morawetz of the Ontario Superior Court of Justice. I asked for a CV from Jeff. He sent me 2 sentences. Unfortunately for him, I know a whole lot more about him. However, I'm only going to say this today. Despite his responsibilities as Chief Justice, Jeff is still very active in the field of restructuring and insolvency, including as co-editor with Dr. Sarra of the Canadian Bible of Insolvency Law, the annual Holden, Morawetz, and Sarra annotated Bankruptcy and Insolvency Act. Jeff has been a member of the III since its inception. So Jeff?
Thank you, Barb. And it is a pleasure to see so many old friends on the screen looking so well and keep well. And like to start just by honoring Ignacio for the first part of his presentation for the best screenshot in behind. The South Sea Island or wherever it was spectacular, but he's now lost the title to Frank Newbold and his lovely seascape in behind him. So it's interesting listening to all the speakers this morning talk about the response that government and the courts and the profession have had to the crisis. And it's quite clear that certainly every country has its specific response, and then region by region around the globe. And then the real challenge is going to be how to recover and how to rehabilitate certain economies when you're coming out of that. Canada's response so far has been rather, from a statutory standpoint, not significant. And I think a lot of this is because our insolvency system is based on debtors taking voluntary action or creditors taking involuntary action, and both are being quite realistic right now, as opposed to some of the European countries where you have obligations on debtors to take certain actions. We really don't have that. So From the standpoint of what creditors are doing, they're really taking a look and taking a very practical approach to date. There has been some statutory assistance provided to specific individual debtors in Canada who have filed either bankruptcy or proposals in bankruptcy. There have been some statutory deadlines from which they have received relief. And that was as a result of province by province court orders, applications being made by the superintendent of bankruptcy, the federal regulator, supported by trustees in bankruptcy and insolvency professionals. So it was really geared to getting those individuals some relief from the absolute time limits in the legislation. But apart from that, there's not been in an insolvency response through legislation. Whether that will change, I think will depend very much on the recovery time period. So to date, we've really just had a suspension of time periods, but I think the next focus is going to be how do you come out of this? From the court standpoint, our courts have always been open, certainly from mid-March when the lockdown came to my part of the country in Ontario. It was pretty significant. All in-court hearings were suspended, but court hearings have been carried on, over 5,000 in the province of Ontario through either teleconference, video, or a combination of both. We're still under a state of emergency here in Ontario until the 1st of June. The expectation is and the hope that there will be a gradual reopening of facilities over the summertime and into the fall, but we really still plan for carrying on in a virtual world because there's no guarantee that you're going to have that reopening. And what that reopening is going to look like is going to vary province by province in Canada. You know, we're 3,000 miles across country, so certain regions are I'm not going to say unaffected, but certainly the impact has been less significant than its other parts. So when the courts do open for in-court hearings, there has to be obviously a real protocol established. It's the social distancing is going to be part of it, but right now we do it virtually. We had a disadvantage going into the pandemic that we were paper-based. So now we've moved from paper-based to electronic filing and document distribution and virtual hearings. And once we come out of it, I think that the way in which court hearings were traditionally held are going to be very, very different. I think you'll have in-court process for matters that are very substantive in nature, and everything that is non-substantive will proceed by way of video. The response from the Canadian judiciary in this area has been to create a national working group. The Chief Justice of each province nominated a judge in that province to take part of it. So there is coordination nationwide as to how courts in the insolvency area should respond, and professional organizations who get together and do provide input to that national working group. So to the extent that there will be statutory reform, it'll be coordinated. As far as government support, it has been widespread for both individuals, small business, large business. There's been a lot of cooperation with our major financial institutions, and I suspect, I have no knowledge, but I suspect that they're going to be engaged in how to go on the path for recovery. Interesting comments from, I think it was from Singapore, that the expectation is that, you know, the economy will be smaller coming out of this. So there'll be significant work for the insolvency professionals. And if we have to add more judges in our commercial group, we will do so. Our courts have been open, as I said from the beginning, and will remain open. Barb, I'll take it back to you at this point.
Thank you, Jeff. Our next speaker is Judge Louise DeCarl Adler of the United States Bankruptcy Court for the Southern District of California. Louise was appointed to the bench in 1984 and has served as the court's chief judge. She's been involved in a number of notable restructurings, most recently the Roman Catholic Diocese for San Diego and Imperial counties. She's been involved in the first cross-border case involving the United States and Japan, in a reorganization involving a national cell phone company, and the reorganization of the San Diego Symphony. She's a notable author on cross-border issues and a director of the III. So Louise?
Thank you very much, Barb. Well, the United States appears to be winning or leading numerically in a competition that no country wants to be engaged in. That is the coronavirus pandemic. From our latest statistics, the ones I just checked yesterday, we've had over 1.4 million persons diagnosed as infected and over 89,000 deaths. And although there is some slowing in these numbers, we are far from returning to normal. The economy, our economy, as all of the previous speakers have said, has been pretty devastated by shelter in place or lockdown orders, which are different on a state-by-state basis. There is no federal response to lockdown. But in some areas, the unemployment rate because of the lockdown orders is extremely high. Some sectors have been hit significantly harder than others. For example, in the leisure and hospitality industry, just last month, it appears that the employment lost some 7.7 million people, or 47% of the people in that industry became unemployed. Although there has been some relaxation of the rules that closed all but the essential businesses, those who are now being permitted to reopen are not exactly springing back to life. So I am going to talk at a macro level, first about the US government's response, then about the court's response, and then finally about the situation in the individual states. The first slide shows you a little bit about the US government response, which is that an aid package was passed called the Coronavirus Aid, Relief, and Economic Security Act. That's the CARES Act. And that was enacted in late March. And it was shortly followed, about less than a month later, by the Payroll Protection Enhancement Act, or the PPPHCE. And the combined acts are over $2 trillion in aid to businesses and individuals. It temporarily amended the bankruptcy code to expand access to smaller businesses, medium-sized businesses, and individuals by raising the debt limit for eligibility to enter into Subchapter 5 of Chapter 11. Now, Subchapter 5 of Chapter 11, or the SBRA, is a kind of a fast-track Chapter 11 that has much tighter time deadlines for reorganizing, and is much simpler. It has form plans of reorganization. It basically is designed to expedite the reorganization process and at significantly less expense than normal Chapter 11. By raising the debt limits and I will speak about that in a little bit, it has encompassed the medium-sized enterprises. The key economic stimulus features of the CARES Act and the PPPHCE are to provide loans, 100% federally backed third-party loans of up to $10 million to help payment of operating costs, payroll, rent, employee health benefits, etc. And those loans, if they are used if 75% of the loans are used for the payment of those kinds of operating expenses, and those operating expenses are equal to 8 weeks. 8 weeks of the loan proceeds are used for operating expenses, then 75% of the loan is going to be forgiven. So there are pretty generous repayment terms for the portions of the loans that aren't forgiven. They have to be repaid over a 2-year period of time, but the interest rate on them is only 1%. So they are facilitated by third-party lenders, but 100% federally backed. Now, about 3 weeks ago, the Small Business Administration, which is a long-established entity, administrative entity in the federal government, which has provided loans to businesses, announced new rules that there would be no lending to businesses in Chapter 11 reorganization. And the stated reason for doing that is that they were concerned that that debtors in bankruptcy would present an unacceptably high risk of an unauthorized use of the funds. Now, apparently the SBA is not terribly familiar with the oversight function that the judges perform in Chapter 11 cases, because they just said no loans to businesses in bankruptcy, which have put some businesses in very difficult choices to leave bankruptcy and try to reapply perhaps for a CARES loan or a PPP loan. There are other direct grants of $10 billion for some businesses, and there's an interesting provision in the CARES Act that gives $17 billion to the SBA to cover loans that it already has, to cover the principal and interest payments of loans that it already has, so that their borrowers can repay them. So that is an interesting features of that. Going to the other areas where there have been some bankruptcy related features to these loans, as I mentioned, the SBRA or the Chapter 5, Subchapter 5 loans have been increased to $7.5 million in debt. Those people holding debt in that amount can file under the Chapter Roman numeral 5. There has been some relief given to debtors who are in individual reorganization cases. That lets them expand their plans to 7 years over the initial or the original limit of 5. And there is some forbearance available on federally backed mortgage loans. Student loans, and this is perhaps not a big component of debt in other countries you will hear from today, but we have 9 million student loan borrowers who are likely going to be getting the benefit of a 6-month suspension in the making of principal and interest payments on federally insured student loans. And during that time, they cannot suffer adverse consequences such as credit reporting agencies saying that they are delinquent, or creditors garnishing or adopting collection actions against them. As to the bankruptcy courts, the next slide, please. As to the bankruptcy courts, as Justice Morawetz has stated, their courts are open for business, our courts are open for business. Telephonic hearings are now becoming common. We already had electronic basis for most of our filings, but now we are talking about video trials and evidentiary hearings to be done that way. The most interesting side effect is the problem of the individual states of the United States. They have been very hard pressed by this pandemic. They cannot borrow in order to balance their budget. They have to balance it on the existing revenues, which of course have been decreased because of the huge unemployment, and the expenses have been increased by the states having to help hospitals get supplies and things of that nature. So the government response to the request by the states for having emergency relief from the federal government has been, well, maybe the states should just file Chapter 9 bankruptcy. The problem is that states cannot file Chapter 9 bankruptcy under Chapter 9. So we are now in a conundrum where there's some discussion of amending Chapter 9 of the Bankruptcy Code to allow
Louise,
states.
Louise, sorry, I have to give you the 1 minute warning.
All right, I am finishing. On our side, the bankruptcy court side, this last month we had a 35% decrease in bankruptcy filings in our district. And we were shocked. But somebody reminded me, you know, in a tsunami, the water goes out before it comes back in. And I think we're looking for the water to come back in. Thank you, Barbara.
Thank you, Louise. Okay. Our next speaker, our last speaker, is Javier Armando Lorente, who is a partner at the firm of Lorente and Lopez in Buenos Aires, Argentina. Javier has lectured and written extensively in the insolvency and restructuring area, and holds academic positions at several law firms and even a few schools of economics. Among other organizations, he is the founder member of the Ibero-American Institute, Insolvency Law Institute, and he's a director of the III. Javier?
Hello, everybody. Thank you for staying long in the seminar, in this webinar. I have been given the task to address the situation of Latin America. As you all know, this is a vast region with a bit less than 700 million of inhabitants and 20 different countries. My purpose is only to address the insolvency approaches to the sanitary, economic, and financial crisis related to COVID. Of course, Latin American insolvency regimes has reacted differently to the pandemic crisis, mostly because the start point for them is different too. Some countries in the region has sophisticated insolvency regimes with very well developed practice, such as Brazil, Colombia, Argentina, even Peru. Others has refined statutory regimes, but because one reason or another, not thoroughly test, like Mexico, for example, they had less than 1,000 insolvency case in 20 years, or Chile, that they have a quite recent insolvency law. And of course, many other countries don't have insolvency status relevant or even insolvency practice. But what I have seen while reviewing all the amendments that already passed in the region or the proposed amendments in the region, that there are common concerns. Those common concerns probably are global concerns, not only regional concerns. That is massive disappearance of enterprises, mostly micro, small and medium ones, despite of governmental aids like there have been in US or that had been explained before. Of course, a huge increase of insolvency filings. The most repeated word has been the word avalanche. We are expecting an avalanche of insolvency filings. And due to that, of course, the courts collapse. That's why the common trends of national responses has been different to what Judge Morawetz explained and the US example. In most of our countries, there has been a mandatory or de facto court recess, except for urgent matters. And believe it or not, both in Mexico, in an airline filing, and in Argentina, insolvency filing has not been considered urgent matters. The exception is Colombia. Colombia keep on working almost normally, and Chile. The second trend of response is an improvement of digitalization of judicial filings and court communication. Again, the very best example is Colombia. Colombia is moved to almost everything digital. And last but not least, there are several proposals of emergency amendments to the insolvency regimes. Next slide, please, Sharon. Which are the common characteristics of the already introduced or pending insolvency reforms? Again, not all countries has introduced or are planning to introduce exactly the same reforms, but some of the following appear in several Latin American countries. First, temporary suspension of individual aggression against the debtor. I mean lawsuits, precautionary measures, creditor involuntary petitions. Second, postponement of deadlines in pending insolvency restructuring cases. Also, rescheduling and renegotiation of obligations born from already confirmed restructuring plans. This is a common trend in most of the countries, the reinforcement or at least a strong recommendation to use out-of-court proceedings, just such as informal negotiation, mediations, etc. Also, introduction of new insolvency features, especially designed for micro, small, and medium businesses, and improvement of liquidation proceedings to easily and effectively return distressed assets to the market. Next slide, please, Sherry. Colombia was the first one that introduced an amendment. It's a very bold amendment. They moved to an expedite admission of the insolvency filings within 3 days, similar to the automatic stay in US. They authorized flexible payments to small creditors up to 5% of the total of liabilities. They are encouraging and improving post-petition financing, deep financing. Again, in a very bold movement, they moved to decentralize insolvency proceedings, allowing chambers of commerce to run insolvency proceedings. And they introduced 2 new insolvency proceedings in which the idea is to have a fast track, shorter, less costly, and more effective. They are even working in a new amendment in Colombia. And in the same idea, Peru last week introduced a new insolvency feature, again, moving to have a fast track accelerated proceeding. In the case of Argentina, giving honor to our proverbial disorganization, we have at least 15 different proposals to amend the insolvency regime. Most of them participate in the common characters that I have already explained, but some of them concur with the necessity to introduce a proceeding for individual micro small businesses, not similar, not akin to the US Chapter 5 of Chapter 11, the Small Businesses Reorganization Act of 2019, but more similar to Chapter 13 of the US Bankruptcy Code. I mean, shorter, less costly, and with wider core power, the cramdown. And finally, the last slide, please, Shari. Brazil is working since April 2 in an amendment of their insolvency law. This amendment has been already amended last week, so some of the things pointed out in the slide, they are not correct, but what they are trying to do is to introduce not a 260-day period, now it's a 90 days period, in which they will have a suspension, a stay of all actions, in which period the debtor can negotiate to a negotiator appointed by the court in order to reach an agreement. And two final things, they are introducing major improvements in the extrajudicial organization, increasing the nature of credits that can be subject to this type of reorganization, reducing the mandatory majorities to obtain the approval of the plan, and granting an automatic stay of this extrajudicial reorganization when filed. And although they have not banned, they are not planning to ban the involuntary petitions by creditors, they are trying to increase the threshold to 100,000 reais to allow a creditor to ask for bankruptcy for a debtor. That's it. Thank you very much.
Okay, thank you. Thank you, Javier. We are now going to open the meeting and see whether we've received any written questions by chat. Sherry, can you tell us whether we have any?
We don't have any questions. We did have a comment from, sorry, I can't see his name, from Rodriguez, commenting on Switzerland's response. So his information is in there if people want to take a look at that. There are no other questions at this time.
Okay. Rodrigo, would you like to, shall we recognize you and you can share your comment with the group? Sherry, would you unmute him?
Yep. Go ahead, Rodrigo.
Hello, can you hear
Yes.
me?
Yes.
Ah, okay, sorry. The connection just went unstable. No, just I only wanted to use the chat to share some information in case there were additional questions. And I thought of it when credits and loans were mentioned, that to cite that this was actually the main approach in Swiss law. It's quite interesting that the COVID-19 restructuring that has been introduced has been used exactly one time according to records. I mean, we have 15,000 insolvencies a year, and the new tool that has been installed has been used once in the last, since it was installed. But we expect that can change. Maybe it was not as useful as expected. But the main feature was that it had actually no access threshold at all. It didn't need to have a plan for restructuring. It was just a stay. You only had to argue that you were not insolvent before last year, and that was all it needs to obtain that stay.
Okay. Would anybody like to raise a question or a comment with using the hands up function on Zoom?
We do have, oh, I'm sorry, Barb.
Go ahead.
One question from Elizabeth Pillen on the chat about the U.S.
Okay.
I'm sorry. For the amendment to Chapter 11, Subchapter 5, is the $7.5 million a max debt level, or could a mid-sized company choose to use that process even if it had higher debt levels? In Canada, we have a bankruptcy proposal process that is available to companies with less than 5 million of debt, but companies with higher debt levels sometimes use that process in part due to the ability to get automatic stay, quick access to commencement of insolvency process.
Okay. Would anyone like to venture a response?
Looks like Chuck Case has a comment on US law. I don't know if it's answering that question or not, but I guess we can see.
Okay. Okay, Chuck?
Chuck,
Hello,
you're muted.
everyone. I don't know whether the audio is working. I hope so.
Yeah.
Yes, we can hear you.
I just wanted to make a comment on the CARES Act and the U.S. response to this that Louise was talking about from a different perspective. I've been retired now for 7 years, and one of the things I do is participate in nonprofit organizations on the boards. And in that capacity, my organization made a request for a PPP loan, a Paycheck Protection Program loan. And this is kind of a little bit of comment from ground level. I mean, this is what it's like doing it. Number one, these are loans that are made by SBA-sponsored banks, and the process was chaotic. The SBA was not, Small Business Administration was not really ready to administer this. And in fact, there were many loopholes. It was designed for small businesses. And at one level, some major organizations figured out how to qualify, primarily because they had subsidiaries running different restaurants or chains or hotels or whatever. And so billions of dollars of this $350 billion package went to the wrong folks. That's one thing that happened. Eventually, my group did get its Paycheck Protection loan in the amount of about $50,000. And it was quite a cumbersome process, but the good news is that it actually is 100% forgivable. If at the end of the 8-week period that you have used it for the proper purposes, primarily payroll, rent, mortgage interest, and other things, it turns into a grant. So it has turned out to be, I think, a lifeline to a lot of small organizations, but it took a while to get there because the system was kind of rigged in the first instance. When it was publicized in the newspapers, for example, that the Los Angeles Lakers got a PPP loan, that was one that caused a reaction among many people. And the SBA took a closer look, and the Treasury Department took a closer look at how the money was being used. And a number of these larger organizations eventually returned the money. But from the ground level, somebody applying for these loans, it was eventually very helpful, but the process was chaotic and highly stressful and not really particularly well thought out. That's my comment.
Thank you, Charles. I think we have firstly, we still have Liz Pilon's question. I'm not sure that anybody took a run at it. Sherry, could I ask you to repeat the question? And then after that, I see that Ignacio has his hand up.
Correct. So it was on the U.S. for the amendment to Chapter 11, Subchapter 5 is the $7.5 million a max debt level, or could a mid-sized company choose to use that process even if it had higher debt levels?
It's a max level, Deborah.
Okay. Thanks, Deborah. Okay, Ignacio.
Thank you. Sorry to take the floor again. It's amazing how New Mexico's changed, Chuck. It's looking really, really nice. Very quickly, I had a question for Rodrigo, actually, because the Swiss solution, which is in a way similar to many others, which is just providing public loans or backing loans by public entities, is coupled with not counting the loan for the purpose of the utility file, if I understand correctly what he said. But it is a loan, isn't it? So it has to be repaid. And what are the conditions? Because that is probably why people are not using it. So it would be very interesting to know if this is some sort of subordinated debt or actually a substitute for equity.
Well, I'm sorry if I was a bit confusing before. The credits are very widely used. They are very generously given because they are granted they're given by the banks, but they are guaranteed by the government, by the Swiss government. So the banks, for once and exceptionally, they are very generous and they just give them away. So I think that's one element that is helping very small and medium enterprises to survive. You only have to prove that you have been subject to legal limitations for your business. So you could not open, you're getting a grant. There is a time limit as to how long you can hide that from your balance. And I'm sorry, I'm just not well informed enough to give you the answer if it's 21 or 22. But at some point, they will have to reappear in the balance. You are given just a certain time for the business to recover and then to repay it. And I think there are some conditions where only exceptionally there would be an enforcement of the debt in case of non-payment. So it's not the idea that non-payment of those loans drives the company into insolvency. But I think they would still be there in case there's insolvency, at least nominally these credits would reappear. That's the mechanism. And what is not used is this COVID-19 insolvency proceeding that is added to the existing one. That is very rarely used. But the credits, the loans are very widely used.
Okay, thank you. I don't see any more hands up. Does it? Okay, Mr. Carlo.
Yes, it's a wonderful meeting and so good to see everybody. I think there are 4 reasons why the bankruptcy is not working well for businesses in the US. One of them is debtors wait too late to file. Of course, the cost involved, and we've made it too difficult. It's too complex. It's not user-friendly, the system itself. But most of all, debtor in possession financing is very hard to get these days, and it's going to, post-COVID, it's going to be impossible. None of these issues are really being addressed by CARES or by anybody else. They're not being discussed. I think we need an immediate response, emergency response that deals with all these issues that makes the system so difficult. The small business chapter 5 is a good beginning, but it doesn't address a lot of these issues. I'd like some comments from some of the people on the board, if you could give me some light as to how this is going to work out.
Would anybody want to comment?
Yeah, Jerry, can you hear me?
Yes.
Yes. Good. I think, frankly, my idea was one that I was taking it away from some of the comments of one of the other speakers, I forget who, that you have an expanded version of Chapter 13 rather than going through the subchapter 5 of Chapter 11 route. As you know, a Chapter 13 is a pretty efficient mechanism. There is no voting by creditors. There is, the debtors has to be very transparent as to the income and expenses and the disposable income that can be used for debt repayment. It follows the usual priorities of the bankruptcy code, the same ones that would be in a Chapter 11 of any sort, either Chapter 5 of Chapter 11 or regular Chapter 11. Obviously, it's got problems when the financing structure of the business is a complex one, but for a simpler business, an expanded Chapter 13 might really make the whole thing much less expensive and expedite it and put time limits on the repayment. Now that they've changed under 1329D, the time period for a Chapter 13 plan to run on existing Chapter 13 plans, expanding them to 7 years for repayment, I think there's a good possibility that some of the businesses, the medium-sized businesses could benefit from that simplification. But I would not look for a congressional response at this point. That's just my sense of it. And sometimes, Jerry, from the point of view of the judge, which you know, be careful what you wish for.
Yeah. Okay.
I agree, Louis, with everything you said, except debtor in possession financing is going to be very difficult. And also you have the inclination right now in the code, even in Chapter 13, is to protect the secured creditors to the utmost. And that's a problem post-COVID. Thank you.
Okay. I don't see any hands up or chat questions. Would anyone like to say anything else?
Oh, I'm sorry, Barbara. Malene had a question and
okay,
had a comment on what Judge Carlo just was talking about.
Okay, go.
So Malene's question was, does someone know what would happen in case a state aid measure, state guaranteed loan, for instance, has been granted to a European firm, although the European eligibility criteria were not met? What would the European authorities be entitled to do? I heard there will be no reimbursement of the capital of the loan, only payments of interest. In France, the state guarantee cannot be voided.
Okay, who would like to attempt that? Ignacio?
Maybe just to say a few words about it, if I may ask again the question.
Yes.
Yeah, because the European legal framework of state aid provides for clear restriction. And so there is a temporary allowance for member states to provide loans. And there are questions because the eligibility criteria have been changed in order to be more flexible for firms in trouble, in difficulties. But we still have questions because it appears that in certain cases, the French legal framework is a little bit more flexible than the European one. So there may be a question whether, for instance, a firm would be granted a loan, a PGE, as explained by Hélène, while actually not being eligible on the basis of European law. And I have a feeling that actually the European authorities would close the eyes, but I'm not sure. And I was wondering whether Ignacio, for instance, would have insider information about this.
Ignacio has his hand up, so perhaps he has.
Thanks. Well, not insider information. I could never admit that. But the truth is, as I said in the introduction, in my brief presentation, it seems like there's going to be forbearance on behalf of the Commission on this matter. So the answer is, of course, not. There's not going to be any looking away, but it might happen. And it would probably have to do with it, because otherwise, you can't just be providing 500 billion euro to a country to help companies restructure, on the other side come and keep the old competition rules, because they're just contradictory. So there has to be an exception to those, either legally written or just by way of forbearance. Definitely.
Okay. Any other questions or comments?
Chuck Case had a comment. If
Okay, Chuck.
that, and I think that will do it.
Chuck.
Can you hear me?
Yes.
I wanted to follow up on Jerry's comment and also part of Louise's presentation. There is nothing specific in the CARES Act. That's the $2 trillion stimulus package that was passed by Congress that would make Chapter 11 debtors ineligible to receive a paycheck protection loan in the context of a debtor in possession financing during bankruptcy. The law itself says nothing about that. It's the SBA, the administrative agency, that is decided as part of its oversight process that it will not approve those kinds of loans. The way the process works is you make an application to a bank. The bank then sends it through a so-called portal to the SBA, and the SBA checks off boxes whether or not you have met the criteria. And they've added a box, which is, are you a debtor in possession or are you in bankruptcy? And they have said, if you are, you're not eligible. So to me, this says a couple of things. Number one, frankly, I think the agency is exceeding its authority, conceivably. It's given generally oversight, but it can't rewrite the law. And number two, it indicates a certain hostility, as Louise said, to Jerry's concept of you need to make debtor in possession financing more available, when in fact you have a law that would otherwise have made it available, but the administrative agency is making it not available. And there's been quite a bit of litigation on this. Oh, here we go. So my dear wife, Pam, just brought me a brand new piece of information on this. One of the judges, Judge David Thuma in Albuquerque, has just ruled that the SBA is outside its authority by saying that a Chapter 11 debtor is not authorized to receive a PPP loan. So the matter is actively being litigated, and at least one bankruptcy judge has now said, you cannot make that, you cannot unilaterally determine SBA that a Chapter 11 debtor is not otherwise entitled. So that's interesting.
Very interesting.
May I make one last final comment to Chuck's comment? There have been about 5 cases already just dealing with this very issue, and Judge Thuma was one of the first, and there have been some injunctions issued by other bankruptcy courts, but there has been one of the judges I believe it was in Delaware, said he did not feel that he had authority to enjoin the SBA from enforcing this. So it is a very lively dispute right now, and I think you're going to see a lot of bankruptcy courts dealing with it.
Thank you. Thanks, Louise. We have time for one more question. Robin Itkin has raised his hand. Robin?
Am I unmuted now? Hi.
Hi.
Hi. So my question with all that litigation with the SBA is, by the time this is decided, I mean, isn't the money going to be gone? I don't know how you rectify the lack of giving these loans when they were needed. So I just don't understand what the result is.
I think, Robin, that you're right. It's going to be very difficult for the latecomers to this game to get these loans. In fact, as you may be aware, the money was gone on the first tranche. It was gone within a week and a half. There were no more loans available. And then the second tranche, the PPP loans came in, and I think that's what Chuck was able to get for his organization. One Chapter 11 case, the Cosi chain of restaurants, apparently has had a derailment of its Chapter 11 because it had applied for these loans, had been preliminarily approved, and then the SBA came up with this new rule saying if you're in Chapter 11, you not only cannot take the loan, you have to repay it, which if you got it, you got to repay it. So you're right. It is not helping people that are really needing the help.
Thank you.
Thank you. And I'm sorry we don't have any more time for questions. I'd like to turn it over to our president, Deborah Grass-Green, who needs no introduction. Deborah?
Good morning, evening, afternoon to everybody. First of all, thank you so much to Barbara, Janis, all of the panelists for this. Put this panel together very quickly. It's been a lively discussion. I think it's been terrific and very informative. As you all know, we're not going to have an in-person annual meeting this year. Really unclear where and when we will be able to have regional or annual meetings. This is a very fluid situation, but the organization has been very adaptable in trying to get our members together to share information because we really need to be on the front lines of what's happening and with respect to change. I just have a couple of announcements. One goes to what Judge Carlo was talking about with respect to changes that are needed. In 2009, after the financial crisis, some of our members, led by Steve Cargman, put together a thought leadership project to quickly identify changes that could be made legislatively around the world in response to that crisis. We're reviving that project. John Martin is going to be heading it up from Australia. I don't think John is on the line. I'm not sure what time it is there. But in any event, if anyone is interested in participating in that thought leadership project, the idea is to harness the resources of the III and try to make suggestions of measures that could be implemented to deal with this crisis. So this is, sometimes something good comes out of something bad, and perhaps some of these changes were needed anyway in different places, and maybe we can make something good come of it. Few other just general comments. As I mentioned, we're not having an in-person annual meeting. We will have a virtual annual meeting, a business meeting. As you know, every year we need to take care of various business functions. You'll be getting a notice of that. It's going to be on June 23rd. Also, all of the regions are going to be hosting, casual get-togethers. We did a COVID coffee break, our first one a few weeks ago with the US, Canada, the Caribbean, and it was really terrific. It was very relaxed and it gave people a chance to talk about what they were facing. It was in the early days of the crisis. So all the other regions are going to be doing that, so please take a look for that. And we're going to be talking with our Programs and Meetings Committee about what types of things we can do differently in this new environment that we're in, because there's so much uncertainty about being able to meet in person. So obviously this format is not an alternative for really the benefit that we get of meeting in person, but this is what we have right now. So we're gonna make the best of what we have. And again, I really thank all the speakers. I know that everyone is incredibly busy at this time, both on business and personal. And so I thank you for taking the time. I think this was really informative, and I hope everyone is safe and healthy and that your families are safe and healthy.
Thank you, Deborah, and stay well, everybody. Till next time.